application of a doctrine or legal principle, the same must have universal application. I say this because not all legal doctrines and principles are universally applicable due to the differences in legal systems, such as the civil and common law. This is also because of our unique peculiarities, such as states due to our historical, cultural, and social systems. My thoughts on this are further fortified by our Constitution, read together with the Judicature Act, Cap 6, laws of Kenya, which allow us to apply the doctrine that are in line with our laws, more so if they assist us better to interpret and apply them. So there's a lot of reading material which I've referred to. So directly is the doctrine. Is the doctrine of basic structure applicable to Kenya? The basic structure doctrine is not only new to our, is not entirely new to our jurisdiction. Much like the other countries, Kenya has had opportunity to grapple with the doctrine of basic structure in our circumstances. During our journey of constitutional making, we had the CKRC appointed in November 2000. The commission chaired by Professor Yash Palgai convened the National Constitutional Conference for discussion, debate, amendment, and adoption of its report and draft bill, famously dubbed the Bomas Conference, due to taking place, which was taking place at the Bomas. The Bomas Conference was convened and adjourned 3 times, out of which a draft was amended and adopted by the acclamation by the conference, sitting in plenary on 23rd March 2003, then handed over the Constitution to the Kenya Review Commission. However, before the conference was adjourned, there was a number of challenges to the validity or legitimacy of the entire constitutional review process and its outcome, one of which was the case that I've referred to, Timothy Njoya and others, versus CKRC. The applicants sought inter alia, that was 2004. The applicants sought inter alia a declaration that certain provisions of the Constitutional Review Act transferred, diluted, and vitiated the constitutional power of the people of Kenya to adopt a new constitution. The court held that the new constitution needed to be ratified through a national referendum, as the right to a referendum was a fundamental right of the people in exercise of their constitutional power. Ringera J., who is now retired, who was in the majority, concurred with the pronouncements of Kesavananda that Parliament did not have the power to alter the basic structure of our Constitution. And there's a citation here, which I don't have to go through, where Justice Ringera, and which means our courts, recognize the principle of, this is my submission, principle of basic structure. Application of the doctrine again arose in the case I referred to, Patrick Ouma Onyango. One of the issues that arose was whether Parliament, in its limited delegated role, had the power to debate, alter, or amend the Bomas draft constitution, which was the product of the view of the people. It was also questioned whether that interference by Parliament had the effect of elevating the members of National Assembly above the people of Kenya as sovereigns. The court, consisting of Nyamo, Wendo, and Mkule, held, and I think I should refer to it very quickly. We further find and declare that what will give purity to the process is the enactment of the proposals as a constitution by the people in the referendum. It is the enactment by the people which gives purity and validity. Yes, they are the touchstone of validity, the people. The applicants in their final written submissions did concede that constitutional power cannot be restrained. We exercise judicial power on behalf of the people, and we cannot restrain for them in making their choice. These are 3 judges of our courts speaking for the people of Kenya. We find and declare that the basic steps in constitution making are 1, popular consultations, 2, framing of the proposals, 3, referendums or Constitutional Assembly elected and mandated. We find the challenge process has satisfied all the 3 steps. We find and declare that the process is not flawed. In our view, the real judges of the process are the people of Kenya in view of the past involvement with the process as outlined. I'm not going to go through all that. There's a lot of material which I will let you read when you get this, this judgment. Basically, it is to show that Kenya itself, due to the constitution-making process that led to 2010, people discussed in depth the history and the problems that Kenya went through, the hyper amendments that we had gone through, and the result was the 2010 Constitution, and in particular, Chapter 16 and Articles 255, 256, 257, which I will be persuading you in this opinion that contains the basic structure that supposed to protect the people from amendments by even the delegated power, which is Parliament. After the promulgation of the Constitution in August 2010, there was a case of the Commission for the Implementation of the Constitution versus National Assembly of Kenya, where the National Assembly, by the Constitutional Amendment Bill 2013, sought to amend Article 260 of the Constitution in respect of the definition of state office. I'd already discussed that. Then there was the case of Priscilla Kivuitu. Then we have various cases. Attorney General versus Randu Nzai, whereby the court held that in view of the foregoing, the appellant's contention that the respondent's agenda of succession is unconstitutional has no basis in law. The respondents have a constitutional right to demand succession, but that can only be done within the confines of the Constitution as stipulated under Articles 255, 256, and 257 of the Constitution. Now, in all these cases, the applicability of the basic structure doctrine was not a substantive question of the courts. The courts were asked to determine, unlike the present one. So in this case, through my proposals here, which I don't wish to go through, and I have told you the art of brevity is not donated to everybody, and I'm not one of them. So I'll let you read. But I'd refer to what I've said here. That there was this decision by Justice Mativo in the Third Alliance case, Kenya versus another versus Head of Public Service, Joseph Kinyua, and others versus Martin Kimani and others. In that case, Justice Mativo said, he referred to this doctrine and he stated as follows: the command in Article 259 is instrumental in shaping the constitutional jurisprudence in this country. Call it by any name, basic structure, or whatever, but Article 259 provides the manner in which the Constitution is to be interpreted to maintain its fabric, which cannot be dismantled by any authority created by the Constitution itself, be it the Parliament, the Executive, or the Judiciary. Couched in this doctrine are a few crucial aspects. First, that constitutions are considered to be the act of the people as the almighty sovereign. We see this as the power of the people recognized and documented in the preamble of our Constitution, which begins as follows, and I quote, "We, the people of Kenya, exercising our sovereign and inalienable right to determine form of government of our country and having participated fully in the making of the Constitution. So I've gone through this, and I invited you, as some of my colleagues have said, some of our judgments are long. Mine is 125, and I would not wish to read through it. I invite you to read carefully, but after going through all my arguments and citing various cases and showing the historical road we passed to acquire, to get this very important Constitution 2010, of which I'm sure all of us are proud of and all of us cherish, I came to the conclusion, my disposition on this issue, first issue, noting our history, context, and constitutional text, I find that the doctrine of basic structure is applicable to Kenya. Further, that the basic structure of a constitution can only be altered or denatured through the primary constituent power. C, it's my further finding that the primary constitutional power is the unbound power of the people to make or unmake constitution, and genuine exercise of the same can be identified by the 4 sequential steps of civic education, public participation, constitution assembly, plus referendum. So I've set out in the judgment what the basic structure entails. And I've set out and I've discussed the issue, where, can the basic structure of the Constitution only be altered through primary constitutional power, and what constitutes the primary power? I've discussed that, and that was my dispensation. So that is my dispensation in that question, and I invite you to read that. So in the interest of brevity of time, I'll go to another issue. Issue number 2. Issue number 2, whether the President can initiate changes, amendments to the Constitution, and whether constitutional amendment can only be initiated by Parliament through a parliamentary initiative under the Article 256 of the Constitution, or through a popular initiative under the Article 257 of the Constitution. I'll give a summarized view of this, which is contained in this opinion and judgment, and also one more issue. The other issue is the place of public, issue number 5, the place of public participation under Article 10 vis-a-vis the role of IBC. The other 3, I wish just to set out and read and state my disposition without going into the details, and I leave that to you to read when you have the time. Regarding question 2, Gatembu J.A. rightly observed that Article 257 makes no qualification of who may or may not promote a popular initiative, and there is no explicit bar against any person, including the President, from promoting a constitution amendment by popular initiative. It is therefore upon the court to interpret and determine the parameters of the same. Now, Justice Tuyot gave the historical context of highlighting the genesis of popular initiative, the clauses in the Constitution. This can be traced back to the CKRC final report, where the Commission noted that although the conference agreed the process of constitutional amendment, this must not be left entirely to Parliament. Different options needed further thought, particularly with regard to the exact modalities of engaging the constituent power of the people. The Commission, in addressing the issue, recommended that citizen and the civil society may initiate constitutional amendments through a process called popular initiative. This was then captured in the zero draft at Article 346, and the same was retained in the Boma's draft as follows, and I quote, an amendment to this constitution may be proposed by popular initiative signed by at least 1 million citizens to vote. So the genesis of the issue of popular initiative was way back during the CKRC conferences. The same survived the Naivasha Accord of November 2004 and the Kilifi Accord of June 2005. And also, it was retained in the harmonized draft. The objective for the popular initiative, as captured by the final report of the Technical Working Group of Group K of the Constitution of Kenya Review Commission on Constitutional Commission and Amendments to the Constitution held up to the creation of 2010 Constitution, the report said a committee introduced a novel idea called popular initiative. This is an innovative where the citizen can only by their own motion initiate amendment to the Constitution by way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament. Tuyot went to hold that, contrary to the AG's submission that the intention of the popular initiative was to curb parliamentary monopoly for both people and state organs, the historical perspective demonstrated that the popular initiative was a preserve of the citizens. It's for this reason that I concur with Kiage J when he concluded that the popular initiative route must be citizen-conceived, citizen-initiated, and citizen-driven process, and the citizens are the ordinary people, whether as individuals or as organized civil groups. Regarding the assertion that the president can initiate process of constitutional amendment by way of popular initiative in his capacity as a private citizen, two pertinent issues arise. First is the fact that Article 257.5 subscribes the president a role in the amendment process. Article 257.5 provides that if a bill to amend the Constitution proposes an amendment relating to matters under Article 255, the President shall, before assenting to the bill, request IEBC to conduct a national referendum within 90 days. The import of this provision is it assigns the President the power to decide whether or not to hold a referendum. To ensure the integrity of the process of constitutional amendment pursuant to Article 257, we cannot have the President playing the role of umpire, who is expected to be neutral and act in the interest of the nation, in a process where he is also a player advocating for his own personal interests and agendas. Clearly, there would be a serious conflict of interest. This would be detrimental to the interests of the people and the nation. Second is that the President ceases to be an ordinary citizen the minute he takes office. Article 131 describes him as the head of state and government, who exercises executive authority of the Republic. He is also the Commander-in-Chief of the Defense Kenya Forces. He chairs the National Security Council pursuant to Article 240, which exercises supervisory control over national security organs, including the Kenya Defense Forces, the National Intelligence Service, and the National Police Service. He is also the symbol of national unity. He plays the various powerful roles pursuant to Article 132, including appointing cabinet secretaries, attorney general, principal secretaries, high commissioners, ambassadors, as well as diplomatic and consular representatives. He is empowered by virtue of Articles 132, 4D and E to declare a state of emergency or declare war, respectively. He may also, pursuant to Article 192, even suspend county governments, either in emergency arising out of internal conflict or war, for any other exceptional circumstances. By virtue of holding this office, the President is accorded immunity with Article 143. So you can see the special position of the President. And we are saying, and I'm saying that the President cannot act as a promoter or initiator, even if you have to use that name, initiator, he cannot commence or get involved. In this particular case, there is evidence that not only did he start the process, but he was also involved throughout, and all steps taken by others the genesis was his own actions through the Gazette notice and the legal steps that he took. This power and control that the president exercises by virtue of his position was evident in the inception of the amendment bill, as rightly pointed out by the learned judges of the superior courts. Right from the handshake that was between him as the elected president following the contentious 2017 general elections and rerun, and his competitor and challenger, Honorable Raila Odinga. He then proceeded to appoint that. So I gave, in this narration, I give the history of all the steps and that he was involved in directly, in the building bridges to a united Kenya, from a nation of blood ties to a nation of ideals, the appointment of the teams, the Gazette notices throughout. The first step had a domino effect, and throughout he was involved, and the government's role was also very clear. The difference in the amendment bill that was launched on 25th November 2020 from the amendment bill contained in the BBI Steering Committee report presented to the President on 26, 2020 are better contextualized in discussing the place of public participation under issue number 5. Now, so my conclusion there is that on whether the President can initiate a popular initiative to amend the Constitution under Article 257, it is my finding that he cannot. Issue number 3, on whether the second schedule to the Constitution of Kenya, Amendment Bill 2020, was unconstitutional, I find that on issue number 3, I find that the second schedule of the Constitution of Kenya Amendment Bill to have been unconstitutional. On question number 4, it is my finding that pursuant to Article 143(2), no civil proceedings can be instituted against the President or person performing the functions of the office of the President during their tenure of office with regard to anything done or not done contrary to the Constitution. And regarding public participation, I wanted to say more, but I will wish to save time, and I will invite you to read the judgment. On issue number 5, I find that by the time the process was stopped by the High Court, the public participation undertaken was not sufficient, reasonable, or meaningful. Issue number 6, I find that the IBC was not properly composed or quoried while it undertook the verification of signatures pursuant to Article 257(4) of the Constitution. However, in the light of the decision in Isaac Biot case, IBC's undertakings in compliance with the decision were lawful. Number 7, it is my finding that the interpretation of Article 257(10) on whether the proposed amendments should be submitted to the people as separate but distinct referendum questions, this issue was not ripe for determination On the issue of costs, I recommend that, being a public interest matter, the parties ought to bear their own costs of proceedings in the High Court, Court of Appeal, and in the present appeals. The final orders of this court are as will be contained in the lead judgment of the Chief Justice and the President of the Court, and which he will advise the court before we end these proceedings. I've had to do this, but I invite you please carefully read my whole judgment. Thank you.
Thank you very much, the Honorable Mr. Justice Ibrahim Mohammed. Allow me now to invite the Honorable Justice Mwiru, the Vice President of the Court, to render her opinion.
Thank you very much, Judge President. The modus operandi today from the side of the court was to deliver summarized versions of the judgment. The 150 plus pages will be at your disposal at your time that the President of the court shall advise. The lead judgment carries all the background to the case quite comprehensively, the history of these proceedings, the fact submissions of all the parties, and the prayers sought. I see no need to rehash that. But at a personal level, I shall read what I consider to be brief. The rest, those who are interested in reading judgments afterwards, shall read. To me, democracy is a perpetually contested condition. Within it, through discourse, persuasion, contention, and reconciliation, we are constantly in mutability towards improving our condition through perfecting the substance of the norms and agreements by which we agree to coexist and flourish. Whilst we see this across our courts every day, there are certain matters that attenuate our constant pursuit of socio-political perfection. The petition before this court is one such. Within the context of our national journey towards perfecting our constitutional democracy, the important role of this court and all parties to this petition becomes all the more apparent. The crux of this petition, as I said, is the extent and nature of constitutional amendment in Kenya, especially within our nation's history of constitutional development, and more specifically, the experiences and processes that birthed the Constitution of Kenya 2010, any initiative that seeks to change that body of fundamental principles according to which we as Kenyans have agreed to be governed, our Constitution deserves the most attention of all Kenyans, whose duty under Article 3 is to respect, to uphold, and defend the Constitution, and all state organs who under Article 2 exercise their delegated authority only through and in accordance with that Constitution. The history of constitutional development in Kenya has been laid out concisely and in detail, both in the High Court and the Court of Appeal, and even in our decisions. This history is most relevant in my view. This court, the Supreme Court, has on numerous occasions asserted the importance of historical context as a key tool for courts and tribunals in the interpretation of the provisions of our transformative charter. Though a significant factor, it is not and ought not be the only lens through or the weightiest factor upon which we consider the questions of constitutional interpretation. Professor Richard Albert referred to in both the judgments of the superior courts below, speaks of the, quote, rise of unamendability, unquote, and the quality of formal amendment rules in terms of their availability for both good and ill, as posing a challenge for constitutionalism, in that though rules of change are indispensable for the functioning of constitutional democracy, they at once, quote, open the door to the demise of constitutional democracy itself, unquote. Therefore, may poses the question, how then, quote, can we protect constitutional democracy from the misuse of its own devices, unquote? The late Professor H.W. Okoth-Ogendo illuminates this discussion by pointing out that it is pointless having a constitution if constitutionalism is not our concern. I am most cognizant of our history as a country, as well as the history of the development of our much cherished 2010 Constitution. I'm also aware of the principles developed by this court regarding historical context in the interpretation of the Constitution, a living document that speaks from the past through the present to the future. I must, however, state that the role of our courts must remain within the architecture of the Constitution. It is bound by it. All courts are bound by it. The exercise of discretion must be judicious. Though it is the court's task to breathe life into the Constitution and to ensure that its text is constantly speaking to the transformative and emancipatory ideals therein, on the other hand, the text of the Constitution cannot be seen as devoid of meaning and content, merely to be filled by ideas and opinions by those on the bench, no matter how laudable and noble and well-intentioned those may be. A balance must be maintained, and such balance is crucial to the very architecture of our constitutional democracy, for the courts too must not see themselves as immune to being inimical, despotic tendencies. This is especially true in regard to constitutional amendment and the exercise of sovereignty as acknowledged in the Constitution directly and indirectly through processes that are prescribed in our Constitution. The courts must seek to steadfastly and purposely defend and protect the Constitution and constitutional processes through which the people of Kenya express their sovereign power, not on the basis of justifiable apprehension, and no matter the nobility of the cause, employ judicial craft to retain certain moral or doctrinal limits into the exercise of such sovereign power. It is the sovereign, the people who must decide, and responsibility of all state organs only exercise state authority as delegated by the sovereign. That is to remove all extra constitutional impediments to the free exercise of such sovereign power. This Constitution has been stretched in its over 10 years existence, and perhaps this is the most serious attempt yet to espouse its limits in the wake of attempted amendments. To demonstrate the magnitude of this case before these courts, while the High Court framed 13 issues for determination arising out of the consolidated petitions, the Court of Appeal expanded them to 21. On our part, we found 7 that required determination, and that's what we are doing this morning, this afternoon. That said, I now proceed to determine the 7 issues as framed in summary as my understanding of the Constitution and the law allows me to do. And the first issue is that doctrine and the basic structure itself. If a doctrine is a legal principle of long usage that is widely accepted as such, then my finding is that the Kesavananda case is a judicial reasoning which cannot be elevated to a doctrine above the Constitution. And therefore, the Constitution of Kenya 2010, I find, has a basic structure. But as for the basic structure doctrine, I find that the same is not derivable from our Constitution, and that structure, wherever else it may be found and applied, does not, in my view, apply in the Kenyan constitutional context. The manner and process through which sovereign power is exercised in this country is by the citizens in its different forms and is fundamentally important under our constitutional architecture, and the Constitution can be changed through other mechanisms, not limited to the primary constituent power. The second issue, the President, in my reading of Article 143, cannot, no, not 143, sorry, issue number 2, the President cannot directly initiate changes or amendments to the Constitution. An amendment of the Constitution can only be initiated through a parliamentary or popular initiative under Articles 256 and 257 of the Constitution of Kenya 2010. Consequently, therefore, the Constitutional Amendment Bill 2010 is unconstitutional. On the third issue, the second schedule